Well, ladies and gentlemen, I don't think we have to stand on formalities. The prosecuting attorney is, for the moment, absent, but apparently is in another court that is in session. And he has not sent the word to us directly. He was going to be delayed, but since we're not standing on formalities, we will proceed with the second phase of the prosecution of the trial involving an alleged, here we go, an alleged murder in outer space. The case really is going forward on two segments. The prosecution this morning and the defense, that is to say, we got the facts in, issues of law were argued, closing statements were made, witnesses testified, and so on. The jury had been impaneled and sworn. They are now prepared to render their verdict in the case. And so I would like to turn to the spokesperson, sometimes referred to the foreman, but in this case possibly the spokesperson for the jury. Would you please come up to the microphone?
We, the jury, find the defendants not guilty.
Yeah!
Thank you.
Good job.
Do it all the time.
All right. Well, that conclusion was not entirely foregone. And though the judges did not have a chance to rule on the facts or the law, we would certainly be supportive of the conclusions of the jury. The scenario calls for the polling of the jury. I'm wondering if there's an interest on the part of either the defense or the prosecution to poll the jury. It may be that some of the jurors would cast an interesting light upon their deliberations, so I would suggest that you proceed along that line.
Yes, Your Honor, we would like the jury poll, please.
Well, can we just start one at a time?
Well, it was actually unanimous. Well, we had at least one dissenter who finally came around. But as generally we felt that it had not been proven beyond a reasonable doubt that it was malicious or a forethought as far as the shutting them up. We believed they felt it was an emergency and they acted as best thought possible.
Let's use the mic.
Well, a number of us felt that the prosecutor had a stronger case against Victor Bruno. that was seemed to be a deliberate act of malicious mischief, or even stronger, maybe terrorism, since it appeared that from the time the computer said that Victor Bruno landed on the asteroid, and 23 minutes later, when the asteroid started heading off towards Island 1, and it had awakened the defendants, and you hadn't reported any movement of the asteroid until after you were already awake and moving into the control room. It appeared that Victor Bruno had sabotaged the whole affair.
There's one right there.
Also, it was felt that prosecution had a hard time proving beyond reasonable doubt that there existed a significant motive to commit the crimes. And also, on the issue of whether or not the computer's testimony should be accepted or not, since it was ruled that it would be accepted for the facts gathered, it didn't make any difference whether it was testimony or whether it had been submitted as evidence.
I felt that it was still questionable. It wasn't proven to me in my mind when and if the station actually started to move, even though they said the computer was able to establish that. I felt the computer could have done a better analysis of the situation in order to clarify in my mind when the events actually took place. I still felt that even though the defendant might have, the victim might have sabotaged the space station, on the other hand, he might have, it might not have, and I felt that there was some malicious intent, but not enough to really validate, to say that it was premeditated, just from testimony spoken earlier in the trial.
And from what I heard in the evidence presented, it was clearly justifiable, the actions taken by the defendants in the case. They saw somebody at their consoles. They saw somebody arrive without announcement. They felt the movement subsequent to that of the asteroid. They then moved forward to remedy the situation, and the first thing is to get the cause or the perceived cause out of the way. So moving the perpetrator into the airlock and to remedy the situation was certainly justifiable in my mind.
Also along the same lines, the prosecution didn't seem to prove his case that they intentionally sabotaged his thruster pack, and that from their point of view, by putting him out into the airlock, it got him out of the way, but did not put him into a fatal situation, so that there was no intent to commit murder.
That concludes jury's comments.
Well, you've heard the jury comments. Now the time has come for the judiciary to comment on some of the issues as they have perceived them. And I would like first to call upon Judge Goldman for his comments.
In the interim, we attempted to seize Peter Bruno, but it's come to our attention that he has stolen a spacecraft and is on his way to the renegade colony on Mars. Now, that's an important comment because actually there is a question raised. It's subtle in here. It was fairly subtle. Is why didn't the Space District bring an indictment against Bruno instead of this indictment against the defendants? And actually, this goes to some of the issues that we were raising in the panel session we just had on dispute resolution. If you have a problem with, if you have a system that's set up to facilitate the conditions in space to keep things harmonious or to keep things going what's good for the colony, you end up often sacrificing the rights of someone else, someone in the colony. And so this case seems to raise due process questions. The venue was shifted, but in question of the indictment, Mack and Griffin, why were you disliked by the colonists? Well, that was the demonstration. In other words, they may have been, from an Earthling standpoint, the better construction company and the ones that we trusted, but they were not trusted by the space colonists and were not able to, they were indicted on very flimsy charges, and the person who was really culpable was able to in a sense, bring this type of case. So I think it raises some interesting questions in terms of, since we are all pro-space, we tend to see the space bearers as the good guys, and the Earthlings are going to be the bad guys. Well, it's not necessarily that clear. And we need to be careful in setting up a legal system in space that makes things run smoothly. We don't end up sacrificing the rights of Americans to due process, just like the British attempted to sacrifice the rights of Englishmen in the colonies in the 1760s.
All right, and Judge Bender?
I've got a couple observations. I guess the first really would be a question to anybody on the jury if they care to comment. And that is, if the computer evidence had been excluded, if you had not been permitted to hear that, would that have made any difference to you in your result?
Not to mine.
Was anybody on the jury bothered by the fact that there was no testimony that the defendants, after they controlled the asteroid, attempted to recover the victim that they put out in space?
Yeah, that bothered me.
Was that discussed?
No, our assumption was that the defendant had an intact spacesuit he got back by himself the same when he got out.
Well, let's assume that the evidence showed that he was out in space for several hours, and during that time, the defendants had not made any effort to recover him. Would that have made a difference in your outcome?
If it had shown that it was beyond the emergency state, that they've got the habitat no longer on a collision course, and they do not try to recover Mr. Bruno, then yeah, it would be much more of an indication that there's more going on there than them just trying to take care of the emergency.
I'm not sure about whether private individuals as opposed to government, let's say for example Coast Guard, whether private individuals are required to retrieve people who are in distress.
I guess
Whether or not they put them there, I guess.
I'm obviously trying to plant a seed, and I don't have a conclusion, but at least to the extent that the justification for expelling Mr. Bruno from the spacecraft was an emergency, once that emergency had ended, out of pure human decency, to think that they might have tried to recover him. I was just wondering if anybody on the jury had wondered about that. I guess a general observation, jurors, I think, have suggested that they decided this case beyond a reasonable doubt. And certainly, as you know from your day-to-day experience, particularly those of you who have served as jurors, that is the standard. And beyond that standard is that the jury has to be unanimous.
I did have some concerns about that, and that's why I originally thought the defendants were guilty, because it was implied to me somewhat in the testimony that they might have had time to bring the victim back in, and they might not have just taken the time. But that wasn't clearly established in any of the testimony that was brought out.
I guess the thing that I'm wondering, and I'm not necessarily asking for a reply, but one of the issues that was presented by the case was whether the space colonists should really be the people to judge people who commit crimes in space. Does that mean that you automatically follow the same standards in space? Do you, in fact, have maintained the proof beyond a reasonable doubt, or do you change the burden of proof to proof by a preponderance of the evidence? That obviously would conflict with my colleague Goldman's comment that you have due process considerations in space, obviously. During the trial, the comment was made that you have to weigh the greatest good of the individual versus the greatest good of the colony. And I simply throw out the question whether if you really were in space in isolated conditions and you had somebody who presented a perpetual threat to the colony, whether that would justify altering the standard of proof in a criminal trial, and or whether it would justify disbanding with the unanimity rule and having convictions allowed by less than 12 jurors or 6 jurors, however many are sitting. That's not totally hypothetical. That has been suggested on Earth. So I just throw that out to you as an observation. I guess my final comment or question to the jury, when the case began, there was a comment to the effect, can an Earth jury properly appreciate the risks, feelings, emotions, special conditions of space during your deliberations? Was that anything that ever became an issue for you?
No?
I guess my final comment would be the observation. I think in this case it probably would not, because the facts and the situations were not, I think, lend themselves to that. But that could very well happen in a particular case, whether somebody in space reacted emotionally different, that on Earth might be deemed to be unreasonable, but in space might very well be considered to be reasonable conduct for a variety of reasons. So the comment would be that there is perhaps the issue of whether cases can be tried by Earth jurors, or whether there has to be some testimony that explain that. In this case, there was some testimony to that effect by the expert, but it's not, I think, a hypothetical question. I think it's a real concern.
Well, I think there would be some problems with that, because if you have an earthbound jury who's not familiar with the problems or consequences of actions that are committed in space, for example, throwing someone out of an airlock, you have a trial by peers on people who are supposed to be basically unfamiliar with the case that you're trying. In other words, they had no exposure to it through the media and propaganda. You may come across a person, and there are many of them out there who have no idea what space is all about, who have no idea what an airlock is, what the danger is of being thrown out of one. We can't simply assume they would know that. And there are certain extenuating circumstances that only a person who has some kind of contact with space, who has learned about it, who has lived there, could possibly understand.
I've got one comments, Judge.
All right, thank you, Judge Bender. Let me ask a few questions for you and also for myself, and make some comments that are essentially legal in nature. At the very beginning, the question was asked whether or not this court has jurisdiction in this matter. And one has to ask what is meant by jurisdiction. And one answer to that is the right of this court to take the case, to hear the evidence, to hear the testimony, to hear the oral argument, to consider the allegations, and finally to come out with a final binding judgment of the matter. That's one way of looking at the jurisdiction of this tribunal. Now, attached to that is the nature of the defendant, who was a United States citizen, this court being a United States District Court. So can we extend through the legislative and constitutional processes in the United States jurisdiction over events such as attempted murder taking place in the outer space environment? Well, I would suggest that the international law and U.S. constitutional law do enable a country to enact criminal statutes applicable to U.S. citizens or nationals who are outside of the United States. That, I think, is a well-established principle. So in that sense, we would have jurisdiction, but that jurisdiction is further subject to the existence of federal laws which would implement that principle. And these federal laws, in their own turn, have to be constitutional. So here we have to go back and look at the ground bases for Congress to adopt the criminal statute that is here before us. I suppose we can look at the foreign commerce provision of Article 1, Section 8 of the Constitution. I suppose we might even want to look at the tax clause, which is more than a tax clause as constitutional lawyers realize. We might want also to look at the necessary and proper clause, which is used to combine other clauses of the Constitution in order to provide the constitutional basis for the jurisdictional statute. I think these are some of the things that a court has to consider. And since, as was said earlier on, this was a case of first instance, this court had to be particularly concerned with those considerations. We decided that the court didn't possess jurisdiction, went forward, subject to the due process considerations of the Fifth Amendment, but always with an eye on the possibility of an appeal from the decision of this court, so that we have protected the constitutional rights of those who are before the tribunal. Another consideration that has been reflected upon by both of my colleagues is the matter of the jurors, and whether or not the accused were actually tried by a jury consisting of their peers. And again, one has to define what is meant by peers. Does peers mean U.S. citizens? U.S. citizens who are living in California? U.S. citizens who have been exposed to space travel and the orbiting experience while it's outer space? These are concerns, and that subject. What might an alternative be? This was attempted murder. This was not murder. Would it be possible for the Congress of the United States to adopt a statute giving to the spacecraft commander summary powers to impose penalties with a identifiable content in terms of the misbehavior that has been engaged in? Would you raise it to the level of attempted murder, or would you put it down at a lower level where there might be a simple offense in the form of a simple battery or a simple attack of a physical nature? Those are issues which would ultimately possibly have to be resolved. Now, let me speculate a little bit before I conclude. Whether the humans who are in space, notice I say humans, I'm not now talking about U.S. citizens, can create their own system of government, or should we on Earth, particularly if they are Americans, create a system of government affecting those who are engaged in space activities? Or to carry this just one step further, if the people in outer space were originally U.S. citizens, could they create a new country and establish their own standards, their own constitutions, their own principles of jurisprudence? And if that were to be regarded as a possibility, even a probability, then the further question arises whether or not those of us who are land-based, earth-based, would be willing to allow those who are space-based to go forward and create their own new country. This would be a form of secession, as it were, from the United States. And one would wonder whether the proclamation on the part of the inhabitants of outer space would be the ultimate factor in resolving that particular issue. So you see, wrapped up in this scenario are a number of fascinating domestic legal problems, statutory problems, constitutional law problems, international law problems, and not to say, and certainly one is unresolved, and will need a lot of thought as to the nature of the jury that would be allowed to arrive at a decision on the law and facts in the case such as this. Now let's hear from the audience. We have some time now to set forth for questions and answers, and I think I received one hand already raised down here. The lady I thought in the front row. Yes.
Yes. I was going to say that in the long run, any extraterrestrial colony will strive for independence. It has always happened that way in a colony. Your own country did that. They will succeed. It will not be prevented. You cannot, nobody will be able to prevent that a colony succeeds in the long run.
Yes, you can. You can H-bomb it.
So they can throw rocks at you. And my point is a harsh business.
This gentleman with his hand up in the right side.
Yeah, I was wondering about the property rights in this case. For example, the airlocks could not be locked, and will you ever be able to lock an airlock if someone is in need and so forth? And was Peter Bruno a burglar at the time, or he was looking for expensive stuff by his own testimony? And I really don't know what the personal property rights are going to be.
The airlock situation was only a temporary situation.
But can you legally lock an airlock if someone is in need? And
That depends on what the law says.
Yes.
And the law will say that you cannot legally lock an airlock because an airlock is a method of safety for some individuals.
Professor Weirin, I believe, has a comment on that.
Yeah, let me address that because there is an analogy that I would draw, and that's to Alaska. I had occasion to serve up there for 3 years, and the law with regard to that in Alaska is evolving. Early on, when it was truly a wilderness, there really were no private property rights. If you had a cabin and there were foodstuffs in it, any passerby was at liberty to utilize those foodstuffs. I suppose there was a moral obligation to replace them or to replenish them if the individual had the capability, but the society never asked that individual to do so. I suppose in an extreme case they would exclude the individual from the society totally, turning him over to the Mounties or whatever it may be. But as Alaska has become more and more settled, then the rules of the game have changed. And then doors did become to be locked. And yes, then you were expected to be on your own because there were means available to you of taking care of yourself. So to the extent that you are in an environment where you cannot take care of yourself, society naturally evolves into a situation where each takes from each other according to each's need. But where you can take care of yourself, then it comes into a society much like you would have in the United States today, where you lock your doors and hold your shotguns at the door for whoever may come in.
Here's a very clear possibility. An individual is in an auto wreck, finds a deserted house, he smashes through the window, gets to the phone, calls up an ambulance, and thereby saves life. But can he then be tried for burglary? Probably no court would convict him.
I don't think so.
That's for prosecutorial discretion, and that's the answer. You would never want a law that was totally enforced.
Defense of necessity.
Follow up. All right, this gentleman over here and follow up. Over here.
I'd like to just extend this comment towards what's been going on here today, and that is that if we accept that in a wilderness situation that there are special laws that are set up, i.e. that there is no such thing as burglary because of the fact that the house is open for the wayward traveler, then in actuality laws that are set up by the federal government to take care of such situations fall apart. And if that's the case, then in a situation, a wilderness situation such as in outer space, the same laws should fall apart, and we get into the problem of whether or not the United States has really jurisprudence in this particular type of case. I mean, if you use that example for burglary, then why can't you use the same argument for a potential situation like this where you have an attempted murder case?
May I just comment myself? I was just thinking as I was hearing this dialogue of the experience in Canada, in the Northwest Territories, that is somewhat parallel to the situation which Professor Lurin brought to our attention. There, the tribal personages are subject to ordinary Canadian law, but they are never penalized. They are prosecuted in the same form. They're never penalized and subject to the same penalties as those who are a part of the larger all-white population. So it is again a situation where special circumstances call for special treatment. I want to pass the question around, and everybody will have a chance to ask you a second and third question. Yes?
Just had a comment to that. Recently, Canadian law has again changed, and now the Native Indians and territories have their own courts and their own form of administration of justice, which is completely different from Western notions. The whole process of dispute resolution is changing very quickly in Indian villages, on reservations.
What happens if an Indian involved in a dispute with a regular Canadian?
Then it is the Canadian courts.
The gentleman on the aisle here.
Yes, there was a question about Bruno taking refuge in the airlock, but actually he had gone back to recover chattel. And my understanding of the law is that if you leave chattel behind somewhere, you have to come back in a reasonable hour and get permission to enter in order to recover.
Bruno didn't know that there was anybody in there. He had every right to think that there's nobody in there. That probably wasn't brought out as well as it should have been.
Oh, yes, no, it was. It was.
All right, all the way to the rear. All right.
My question is addressed to problems that I perceive with dealing with circumstantial evidence. This case seemed to mainly revolve around that since we had no direct witnesses other than the purported victim and the alleged defendants. So if that's always seems to present more of a problem when it comes to fighting out this kind of a case, it would seem that in outer space it's going to be more likely to be that way because there are going to be fewer people out there and there are greater distances involved. So my question is addressed to you, people representing the judicial end. Would there be reason to give further thought to the evidentiary rules where it's concerned with the use of circumstantial evidence?
Sure, I think everything in space has to be rethought, and no matter what type of rule you try to construct, you can always have problems. I'll just give you perhaps a practical analogy. In drunk driving cases, normally you do not have a videotape of the alleged drunk driver on the night of the incident. But in the past, there have been police stations which would videotape a drunk driver and play that in front of the jury. And that's a two-edged sword, because on the one hand, once the jurors become aware of that, and that's common knowledge in the juror pool, then everybody expects to see a tape of the drunk defendant before they will convict the person. Well, if you were in space, presumably you would have many monitors. You might ask, for instance, well, wasn't there a monitor that filmed the struggle between Bruno and the two defendants, and why wasn't there a film presented to us to show whether the suit was intentionally damaged and the back ripped off, or whether it was accidental? So that's an example where you could perhaps change the rule dealing with circumstantial evidence, but it could simply lead to a greater complication. But I think your initial observation is correct. You just cannot take for granted that the same rules that we apply on Earth will automatically apply in space, and circumstantial evidence certainly would be one of those you have to look at.
May I respond to a somewhat collateral problem which I imply from your question, that is as to evidence as such. And one of the things which is not fully covered here, and it was possibly not necessary in the scenario, was as to the right to a speedy trial. And one of the questions is, how long can the facts be held, so to speak, in the freezer or on cold storage, and still have the witnesses, when they come along, have a fresh and accurate recollection of what actually transpired, so that we have not only circumstantial evidence, but the right to a speedy trial that is involved here. Also a constitutional protection, by the way. This gentleman over here.
Yeah, I think what you're saying also brings up some practical issues also. Let's say that instead of being a case exactly the way it was, that you have other witnesses, such as people in the control room and others, that during the run of the trial, you might want to call those witnesses, because suddenly the fact which they may be able to testify about becomes important, except that now they have to be, 3 months or a year or a week away, and you have to put the whole trial on hold to bring those people in. It seems like a serious problem.
Directly addressing that is a possible solution is the allowance of remote testimony.
The acquitted novel speech.
Yeah, I was just thinking about something very similar to that. Suppose this had not taken place in this event had not taken place in lunar orbit. Suppose this had not taken place in lunar orbit, but perhaps on one of the Galilean moons. And suppose my wife and myself had spent 2 years on a spacecraft in confined quarters, coming to this trial, and say we've been found guilty. Would that have qualified as time student?
Furthermore, how many light years would you get?
Now, this gentleman in the back here, yes, the bottom of the blonde hair.
Mine?
Yeah, you're the one.
Yeah, I was wondering also about the airlock question. The fact that you would have distinctly limited resources in many of these places. The wayfarer coming in to use your airlock may use up so much oxygen that there's not enough for both. If you have a station with 2.5 people's worth of air supply, 2 people and a third comes in, it's just a lifeboat. Yeah.
I didn't know all that.
Well, I can comment on that. I think, for me, the central focus of this kind of a trial, and I have something of an historical perspective, is is the Bill of Rights an historical aberration? Or is it something that humankind is willing to take forward into space? we are only one of many competing models for the ultimate law that transcends the Earth and goes into space. This country was protected by its geographic isolation until this century, and in this century it's been protected by its being the only economy left standing after 2 world wars. We've had sort of the luxury of a Bill of Rights. It's very expensive for us to have this view of the individual that the rest of the world does not share. Human life is very cheap in most other parts of this world. And if you look at the models, specifically turning to the law now, if you look at the models that have served to form the basis of what space law now exists, you will find that space law draws very heavily, not in these issues because there's very little space criminal law right now, but draws very heavily on two models. One is the law of Antarctica, and the other is military law, if you will, but the law of the sea, admiralty law, or the law of what do you do on a ship. And that law goes back 2,000 years and before. You probably know that a ship's captain, and if you look at the Star Trek series, you can see this too, has a lot more authority to resolve most disputes on that ship. So if that process continues, where we look to the law of Antarctica, and if we look to the previous military model, and I have significant experience in the Uniform Code of Military Justice, which we use that's what we use in the American system today. That has been a parallel development. There is still a lot of questions about how the UCMJ fits into the Constitution. So I'm just saying that the UCMJ is something that we, as basic Americans, take for granted. It's been in our TV programming as we've grown up. It's been in our historical development. But it is not something that has had to have been there. It's not something that any other country really has to the same extent that we do. A number of third world countries have copied our Constitution. It's there and written. But we have the only real long-term successful incorporation of the rights of the individual versus society. It's because of our pioneering spirit and our cowboy. But is that going to go into space? To me, that's sort of the ultimate question.
Professor Weirin?
I would make 2 observations, and I think Bruce is very correct. I have about 30 years experience with the Uniform Code of Military Justice, and as it currently stands, there is serious question as to whether or not the Uniform Code of Military Justice can withstand a war. It's a nice system during times of peace, but it does not have the elasticity within it to deal with immediate crises and all of the refinements which the Bill of Rights would give to a civilian population and now a military population when there is time and lawyers and facilities are available to afford these kinds of investigations and what have you. And indeed, very learned people in military justice circles feel that probably the present Uniform Code will not survive, that it's not practical in that kind of an emergent situation. And exactly what Bruce was saying is that probably it's not a good model for a space law because there are emergent circumstances that are just happening too quickly. You have to make decisions too quickly. With regard to Antarctica, my concept would be that those are the rules written for a scientific community with no significant political and no significant economic factors at work, and that therefore that model is not likely to pertain to a space environment unless, again, it is solely for scientific purposes. If it goes beyond that and becomes either economic or militarily viable, then a different system of rules and of visitation and all the rest of it will necessarily occur. Did you have a comment, Craig?
Oh, I had a question. I'm trying to avoid the facetious nature of the question, but I guess the question is, some individuals would think all lawyers should be sent into space. And
others be selective, I know.
Right, without us. And other individuals
begin to say, well, is a lawyer important in space when you have limited access to those to space? You have engineers and mission specialists and people that have to perform duties which keep the system functioning, and law is central to the human interaction, but is a lawyer important in space, and what degree does that importance fall? Or should the captain of the ship have a law degree, or should one of the first mates have a law degree?
Oh, I'd like to respond to that and to Bill's statement. First, on that issue, law has to go into space because the alternative is anarchy. So someone with legal training has to be there. Now, in our tradition, that's the lawyer going into space will have some expertise other than that, administrative, computer, and that's American tradition. The cowboy, the lawyer with the law books in his backpack, or Lincoln the rail splitter, it'll be Lincoln the computer programmer in space. So that's an American tradition. So I see, yes, the first lawyers in space are going to have other duties, but they're going to have to be there. Then the other thing I'd like to respond to is the thing we've been getting at. I'd like to come out in defense of the U.S. Constitution and the Bill of Rights, mainly because on the grounds that the Bill of Rights itself is flexible. The Due Process Clause, and I'm a strict constructionist, so this part's company is slightly with strict construction, not totally. The Due Process Clause is an old concept in common law. It goes all the way back to the 13th century. The Magna Carta, when King John signed it, there the language was the law of the land, so that the king is subject to the law of the land, and the peers were given rights under that. And that 700-year history is that the law of the land, the due process, is evolving. It is the process that is due under the circumstance. And so I think the Constitution does have that flexibility. Now, I want to say something else on that. I don't want to draw it to the extent that it becomes, it can expand indefinitely. In other words, maybe a crisis. The Constitution was written in a crisis. That's been written, actually some of the Supreme Court opinions have said that. So to argue that we've got a crisis situation so the Constitution doesn't apply is considered to be a bogus argument, because our Constitution was written in a crisis situation. And so that flexibility in it permits an expansion, but only within certain bounds. In other words, First Amendment, you can't yell fire in a crowded spaceship. Second Amendment, right to bear arms. Well, what about carrying a loaded gun on a spaceship? And you can go through them. So, but I think our Constitution has the flexibility, and that's how it survived, basically intact for over 200 years now.
Gentleman on the aisle here, please.
Yes. Harking back to an earlier discussion, and this was the area of supplies for wayfarers, and Mr. Warren could answer this. Back when you had to keep your doors unlocked in Alaska, did that mean that a wayfarer had the run of the entire house, or could you restrict him to an area with supplies and shelter and reserve the rest of the house? Might just apply.
That's an easy answer. There's only one room.
Yeah, just to add to some of the things that you were just saying, I think that there really is a model already, because most of the West was won under the U.S. Constitution and under a pioneer situation where sometimes frontier justice was done. And I think what it basically comes down to is that under certain practical situations, some of the niceties of laws are just temporarily forgotten. But the fact that the law still exists means that it eventually does come back into force. And you don't want to give up the thought that you have those rights. You may have practical concerns for a while that you look the other way, but you still have the long-term goal to get back to the due process.
May I just comment on that? I think that you use the term forgotten, and I think I would take objection to that. I think that what we have to do here is to, as Judge Goldman has said, apply the Constitution. But that application could be delayed, as it was in this very tribunal, until the accused are in court before us. So the Constitution is still applicable, the delay in the application of it would be the only difference. Well, I'm advised that our time has now come to one more point, if we're swearing in.
I would like to make a motion, Your Honor, that we give a round of applause to the author.
Let me conclude then by saying as follows. We appreciate the stimulating and attentive audience, the good work of counsel and co-counsel, the Herculean efforts of the witnesses, our thanks to the jury, my fellow judges, and of course, the author of the scenario, Wayne White. So with this, we stand adjourned. Thank you very much.